All right, well, welcome everyone. It's good to see such a full room here today of lots of you I know, and I'm pleased to have you here. Some are current students, some are former students, and it's a real pleasure to see you all. I think the topic is one of tremendous interest, and our speaker is one who is very engaging. You'll see here shortly. But I am Peter Dutton. I am an adjunct faculty member here at the NYU Law School. I teach Chinese attitudes on international law with Jerry Cohen, the legendary Jerry Cohen, and I am pleased to be able to host some of these events here through the US Asia Law Institute and to host some of our discussions. So welcome to all those of you out in Zoom land as well. We're pleased to have you joining us today. And if you have questions, I take it there's a question box that they can go ahead and type their questions in, and when the time comes, we'll make sure that we get to as many of those as possible. My guest today is Isaac Kardon, a longtime friend and sometime colleague, working together various iterations of our lives, and always a gentleman scholar. And so Isaac Kardon's, the reason we have him here today is that he has published a new book, China's Law of the Sea. For those of you in the room, we have flyers that if you're interested in the book, you can purchase it with a discount, I think, yeah. And it's by Yale University Press. And I have to tell you, it is a really good volume. I've been through every single chapter very carefully, and this is a topic Isaac knows I know well, and I'm really impressed with what you put together, Isaac. But before we get into your really terrific volume, I'd like to ask you a little bit about yourself, so that the people here in the room and then the people joining us on Zoom know a little bit about you. So first, I'm going to ask you. I'm going to play Jerry Cohen here. Comrade, where were you born?
Well, thank you so much, Peter, for that really kind introduction. I was born not far from here, up at Lenox Hill Hospital.
Yeah.
So,
talk about a local boy. Yeah.
yes,
Good.
That's right. And we actually lived around the corner from here when I was born on King Street. So, this is quite close to the epicenter.
So tell us about how tell us about your education. How did you come about these particular interests?
Well, it was definitely not a linear process towards writing on China's maritime disputes and maritime law, but I started out studying history, and primarily of the US in the Cold War in the Middle East, because I had started college in September 2001, and that seemed to be the center of the universe. And I think through some accidents and good stumbles into not the direction I intended, I discovered that I had not focused on China or East Asia at all, and somehow was studying US foreign policy in the middle of the Suez Crisis in the 1950s. And I couldn't find anything about the Middle East in the records of one of Jerry's favorite and most notorious antagonists, John Foster Dulles, who was the Secretary of State for Eisenhower during both of these periods, Suez in 1956, the Taiwan Straits crisis, bracketing it in 54 and 58. And I was trying to do research on Suez, but I ended up doing research on the Taiwan Straits crises in the 50s, because that's all that was there. I think the rest was in Abilene, Kansas, in the Eisenhower Library, and that just sort of launched me in this direction towards wanting to know more about China, and had the opportunity to fall in with people like Jerry Cohen and yourself over the course of my graduate studies. That's how I gradually focused down on China and maritime law and power issues.
So you studied history as an undergraduate at Dartmouth, I believe.
That's right.
Then what?
So then at the very end of that was when I kind of had this realization that, man, I haven't learned very much at all about China. And I had a chance to travel there. And then I ended up realizing the one thing I really needed to do anything was language skills and some foundational knowledge on Chinese society and history and politics. And that led me to Oxford, where I did an M.Phil, a really unique program there where you spend much of the time at Beida in Peking University doing language and also being set up to do your own original research. And that was really the beginnings of thinking, oh, well, maybe I could be a scholar for real. And sort of after that, I ended up working in DC for.
Well, let's pause on
Yeah,
Oxford for a minute. So you have an M.Phil in what? And how did it lead you to China?
So the M.Phil is in modern Chinese studies.
Oh,
So
okay.
I had already led myself to the
I see.
question of
Through the Taiwan
I wanted.
studies.
That's right. I wanted to learn language, and I also wanted to learn something about the politics and history. That was my orientation. Is somehow I'd been studying the Cold War, and I'd missed this, continental sized part of the story that. I mean, it wasn't that I was entirely unaware, but it's just that I'd been so focused on the Middle East, which felt more and more tragic to me. And I'm talking about sort of the mid aughts, 2005 to 2009. And I started to get opportunities to go to China and found studying the language was something that I enjoyed and was rewarding. And, it's just sort of a lot of positive feedback. It's interesting, it's dynamic, it's important.
China was very open during that time too.
That's
And, that's a topic I want to come back to. But so in that period of time, you were studying China through Oxford, but then also apparently at Beida, Peking University, Beijing University. And so you were at Beida for how long? What, semester?
For a semester, but then I was in China for the better part of that year. So
Okay.
I stayed summer of 2008. Stayed in Beijing after we'd done our semester there, and started my own research and got a chance to see probably the peak of China's openness and its, I'd say, positive global branding in some ways. The 2008 Olympics were really quite extraordinary in that regard. And that was the beginning.
You were there that summer. Yeah.
I was there that summer, and then I was in Taiwan the following year. So that's actually the key juncture for starting to specialize in the path that led to this book and our work together, which was, as you will know well, Peter, in May 2009, the People's Republic of China published this mysterious 9-dash line. And I was in Taiwan at the time studying language, but I was a research assistant to a fellow called Wang Quanxiang, whom you know, Dustin Wang, who's a UK trained international law specialist who had studied China and law of the sea issues. And at that precise moment, I was there working for him, and he got me spun up on, let's find out everything we can about the 9-dash line. And I've sort of never looked back.
Yeah, that's great.
So fascinating and obviously so consequential.
And then you went to Cornell for your PhD.
I did. A brief interlude in DC before that. I worked for Phil Saunders.
Oh, that's right. Yeah.
I got that job while I was in Taiwan.
So who's Phil Saunders and where does he work?
Sure. So Phil Saunders is one of the, if not the leading scholar of the People's Liberation Army in the US. He works for the National Defense University. And he hired me out of my Chinese studies master's to be a research assistant and to support their work on things like China's military transparency and maritime disputes, which was the subject that I came in saying, I'm really geared up on this. I've been in Taiwan studying the 9-dash line. I'd like to keep working on it. And that was what gave me the interest to then go on to Cornell and say, if I really want to understand this, I'm going to have to do things like spend a lot of time in China researching maritime law and maritime disputes.
I was working with Phil on maritime disputes during that time frame. I have vague memories that's probably the first time we met during that time frame. But so you went to Cornell for your PhD. What was your thesis?
So my thesis was called Rising Power, Creeping Jurisdiction.
Yeah.
And then the subtitle was China's Law of the Sea, which is what this attractive volume on the table is called now. And it's the beta version of this. For anybody who has written the dissertation, you'll know that the dissertation is for your committee and probably no one else. So I was able to successfully throw away that document digitally. As it turned out, I sort of just needed to start afresh. And it's basically been something I've been working on and thinking about since then, since 2009, when I really got going.
Before you were awarded your PhD, you spent some time here.
Did. It was Jerry Cohen and Peter Dutton were instrumental and foundational to me being able to do the research that goes into this book. While at Cornell, started commuting into NYU Law to take Jerry's class on Chinese attitudes towards international law, because it was the only thing on that subject, and Jerry is by far the greatest teacher on that subject, and that put me into this whole universe. And so while I was at Cornell, I was looking to specialize in comparative law, as it turns out, and international law. I didn't know this as a political science Ph.D. student, but ultimately this was putting me squarely in that particular part of legal academia, and the US Asia Law Institute here provided that opportunity to really learn something from you, from Jerry, and from people like Jose and others in the international, or in the law school here, who focus on Asia and international law.
Yeah, I think you're honestly a shining example of what can be accomplished with an institute like this, and the contributions, that the time, just the sheer time, surrounded by the right people, and the scholarship that can come from that, it just demonstrates really the value of this kind of an organization. And I'm pleased we have Catherine Wilhelm off camera. We have Catherine Wilhelm with us, who is the executive director of the US Asia Law Institute. I should have noted that earlier, but thank you. Okay. Before we get into some specific topics about the book, one of the things, as I said earlier, I read it all. It's very well done. And part of what makes it very well done is you have done a really good job of mining Chinese language sources. Really good job. That's not an easy thing to do, especially now. Before we get into some of the details about that, I'm interested. Really, what I'm sad to see is the rapidly decreasing access to Chinese language sources. Some of this is through the through the constriction of CNKI, the China National Knowledge Infrastructure Database, right, which is a scholarly database that's being just in the last month or so has been almost shut off. And in some places it's been entirely shut off, and in other places it's been partially shut off. The problem with that is how are we in the rest of the world to be able to understand China sufficiently to understand it and to share, right, the things that we know about China, so that we can help the world understand the perspectives China comes from. Tell us about your archival research and how you were able to do it.
So this is a hugely important question for anybody who wants to do research on China, but I think also for everyone else too, because we all need people doing specialized research on China and whatever subject matter is of interest to us, because of how important China is. I have used CNKI in particular very extensively. We, of course, used it at the China Maritime Studies Institute. That subscription is now null. So are most institutional ones, certainly ones associated with the US federal government. And I also, in the course of this, just talking about access more broadly, I was a guest of a state think tank in Hainan, funded by the US Fulbright program, but nonetheless there as a guest with a danwei, for people who are familiar with how important that is to just be able to operate in China and go to meetings and talk to people and not have a big problem. That type of access is pretty hard to imagine happening now, even for a graduate student, which I was at the time. And so I think we're now in a world where we're going to need to be creative and entrepreneurial and figure out different and new ways to get access to China. But I don't have a ready substitute, frankly, for the access that we got from obviously the physical engagement that's become possible again, but under different constraints. But then the digital side, like we used to read Chinese law journal articles and publications by the PLA's Transportation Academy and things like that are available and help you learn about the discussion in China among your counterparts effectively, specialized people who are in academia, government, think tank. And it's not easy to get that now. I think there may or may not be some workarounds that we can use, but certainly nothing at scale, and certainly nothing that allows a broad open user base quite the way that we had before. So I think we're all in need of an institutional solution for this. And I think it's important, even for people who aren't going to use those sources, that knowledge is accessible.
Do you think you could have written this book today?
I don't. I really don't. I think I could write a book and I would have to, again, be creative about how I got to sources. One thing that I've been doing over the last few years to learn about China and to continue my knowledge and specialization is going to third countries who also interact with China in a particular way. And you can learn something from their interactions with China, but it's those direct, whether in China or in the Chinese internet, as it were, types of points of access and relationships with people and knowledge of editors and publications and who's who and who's cited and all of that stuff. We're going to be losing that. That's attenuating as we speak. That's withering on the vine. And I am worried that the types of scholarship that I think are necessary are going to be much, much harder to come by.
Well, it's a particularly fraught period of time right now, politically and in terms of security between the United States and China. And so having the ability to understand China is more important now than ever, I would say. And so one of the things that I want to ask you about, we'll turn to the topics addressed in the book, is just broadly, in terms of its maritime disputes in the South China Sea. Everybody's heard a lot about the disputes in the South China Sea, and we have a few maps we could show if we need to. But what do you think China is trying to change through those disputes? That's a broad question, I know. What do you think they're trying to change?
I think that's a great way of posing it in a way that I can give myself enough rope to hang myself with here. But I think there are a couple of things that they're trying to change. One thing that I can say quite concretely and specifically, and I think that you could learn a lot about in this book, is that the textbook application of the law of the sea in the South China Sea is something that China does not intend to see. And so in that sense, that's something they'd like to change. This expectation that, actually, if we could pull up the slides, we could kind of gesture at the map. But the idea that the law of the sea, specifically as codified in the treaty, is going to create things like a big 200 nautical mile exclusive economic zone for the Vietnamese or for the Philippines or for, frankly, any other littoral state in the South China Sea, I think is something China would like to change. The expectation that the law of the sea applies ipso facto, just as those are the rules, and they're going to be applied uniformly across that space. That's quite explicit in their practice. They're not allowing the law of the sea to be directly applied. That's one way that we can, I'd say, there's not a lot that you can say positively about what the 9-dash line is, but as a negative matter, it clearly denies the ability for littoral states, other coastal states on the South China Sea, to have their full entitlements under the law of the sea.
So do we have that map available?
Yeah, let's see what we can pull up here. So
yeah, there we go.
So these are, so for the record, these are maps from the book that I commissioned to specifically represent China's law of the sea. This is not something that you will see in parts of this. You'll see in China's UN submissions, parts of it you'll see in their domestic law, but this doesn't show any of the other littoral states' claims, any of the other claimants across the whole of the East Asian littoral, which it bears noting, China doesn't have any resolved maritime boundaries there. What this is notionally.
So a small correction, right, which is the only resolved maritime boundary they have is in the Gulf of Tonkin.
They have a partially resolved boundary, and I don't know if folks on Zoom will be able to see this, but I'm pointing to this little area next to Hainan. This is where I was based, right here in Haikou, for the record, when I was doing a lot of research for this. But right over here is part of the very quite long, presumably, Vietnam-China boundary, or at least what China intends to be a quite long Vietnam-China boundary in the maritime space.
So I need to interject at that about that, because I need to have a little public service announcement about US Naval Law Institute, which is that we just held the third round of our Maritime Dispute Resolution Workshop series where you presented a case study on that delimitation. We've been studying maritime delimitation and maritime dispute resolution, really, here at the US Asia Law Institute under a grant from the Japanese government for now about 4 or 5 years. And so what we're really trying to do ultimately is to help think through how to assist Asians in either managing or resolving these disputes. So I needed to point that out because it's a terrific case study that you've done.
Thank you. And I guess just to kind of close us on what China is looking to change. So again, these are notional, and these are assessments of what China's rule is or their practice put into map form. And what you can see quite clearly is there's not a ton of room here for, and let me go back to the boundary map here, like China would like to change the maritime boundaries, South China Sea. It's not clear exactly what they intend for those to be. The 9-dash line, I think, is the gist of it, I suppose, but they've obviously created a bunch of different ways of claiming Chinese maritime rights and interests, is the term they typically use for it. And I think it basically is, it's narrowing the scope for the application of, the textbook version of the law of the sea. And by that same token, opening the scope for political negotiation over what the boundaries should be, what the rules should be for who owns the resources, who gets to navigate where and under what circumstances, and all manner of other things that are nominally regulated by the law of the sea, but that China doesn't see as fully generating the rules for the South China Sea or the Yellow Sea or the East China Sea. It's worth noting. There are different issues at play in each of these bodies of water, which I think is worth exploring as well. South China Sea has quite understandably taken up more of the attention. It obviously involves more players.
Sure.
Just looking at this map without even interpreting any of the lines, you can see it's much messier. Everything is wrapped around itself. But nonetheless, we see some quite significant commonalities across China's law of the sea generally, all the areas that China's claiming some type of maritime jurisdiction, some type of sovereign rights, some type of historic rights, some type of basically indeterminate claims to sovereign authority.
Well, so as complex as it is in the South China Sea, we're looking at the map, and we also know that in the East China Sea, there's disputes between China and Japan and South Korea as to exactly how to delimit the boundaries, but also the sovereignty disputes over the islands there. The Chinese call them Diaoyudao, the Diaoyutai, right, are the Taiwanese, and then there's the Senkaku, right? So
I'm just trying to point out with the laser action if I can.
But also just in the past week or so, there's been incidents between incidents involving the Chinese, the North Koreans, and the South Koreans in the Yellow Sea, right, over fishing rights. So it's a really active area. We hear a lot about the US-China interaction, but there's certainly a lot more going on than that.
There is, and I think it is a broader phenomenon. There's some part of it that is general across the littoral, which is that China has what the US State Department excessive claims to maritime jurisdiction across this space. At a minimum, their claims that are in dispute with their neighbors. Again, across their whole littoral, including North Korea, their only treaty ally. They don't have a resolved boundary, and it's because China's claims are such that they're now enforcing China's domestic maritime law in areas that all of their neighboring states also claim as areas where they should have some jurisdiction and some sovereign rights.
So I want to come to that point, actually, because you have a quote in the book that I thought was quite revealing. What you said is, this is in the navigational rights section, but it really pertains broadly. PRC practice reveals that the coastal state's sovereignty, or sovereign discretion, I should say, is the operative element in China's view of international law. So talk to us a little bit about that and how it affects that viewpoint affects China's view of international law of the sea broadly.
Thank you. And that's really the through line that I have been pulling in a way since I started here at NYU in Jerry's class that then included you, and now is yours primarily on Chinese attitudes towards international law. And I actually cite Jerry's work quite extensively in one of the chapters on this, developing this idea. But it's very difficult to find consistency and uniformity in China's practice of maritime law overall, unless you think of this principle of coastal state sovereignty, that's the applicable part in the law of the sea at least, as granting some type of blanket discretion to the coastal state to interpret the law of the sea almost in an ad hoc idiosyncratic way, depending on the case. And we can look at some of these and really pull that out. But the core premise, I would argue, in all of China's legal practice that I've observed, but in this case, very intensively in the law of the sea, is that they have what maybe the 19th century Europeans who were originally developing ideas about Westphalian sovereignty and what it should mean in a modern institutionalized legal system. They believe sovereignty is absolute in some fundamental ways. And the Chinese party state, as it has always engaged with international law, which we've learned from Jerry since 1949, and the law of the sea is no different in that regard. There is a hardcore of sovereign inviolability, you might call it. They sometimes invoke the sacredness of sovereignty as basically something that there can't be any type of transnational law or universal jurisdiction or any of these more generalizable ways that states have to be bound by the international law. What we see in Chinese practice, and I think especially acutely in the law of the sea, because that's where they're getting contested on it, or that's where that's meeting conflicts with, in particular, regional states, which is a key theme of this. China's sovereignty creates a type of contradiction. China is claiming sovereignty over territories that it does not de facto control, and at a minimum that other states don't accept that it has sovereignty over. And then it's applying its sovereignty in a way that that degrades their sovereignty from their standpoint. It's quite an extreme version of what does it mean to be a sovereign state in the international system. At some level, what China is saying is a sovereign state gets to decide the nature of how it interprets the law of the sea almost across the board.
So let's talk about this. So sovereign discretion, right, is the phrase that you use, and I think it's a terrific one. How does that affect China's view about maritime dispute resolution?
That's where I think it is most easily discerned and most impactful specifically in dispute resolution and the ways that China is willing to accept beforehand in treaty form, as well as certainly in the ways it's going to practice in the event, which is anything that can be construed in any way to bear on China's sovereignty is going to be completely ruled out of any third-party dispute resolution. The idea even of a mediation or of an arbitration or conciliation, I think, is basically off the table. What China says, and they say this not just in maritime, but in all their legal practices, that bilateral dialogue and consultation is the way you deal with anything that has any nexus with sovereignty for them. They will, in theory, shelve disputes and pursue joint development in the maritime space. But what they mean by that is saying, if you want to talk about sovereignty, that's a purely bilateral, purely private matter. It's not regulated by public international law. That's the statement on it. And it has to do with sovereign states are, in fact, under international law, even if you don't have this, what Ian Johnston calls a hyper-sovereigntist view of sovereignty, the norm in international law. Any sovereign state has discretion to say bilateral dispute and consultation.
Well, let's talk about that, right? Every sovereign state has discretion, right, to accept or not accept, for instance, a treaty, right? And the responsibilities that come with, for instance, the Law of the Sea Convention, and that is to say the dispute resolution mechanisms of the Law of the Sea Convention. So the argument that China's neighbors put forth is, well, look, you exercised your sovereignty when you joined the convention and its requirements for dispute resolution. Right. Yeah. So isn't there a tension there between China's claim now that my sovereignty means I don't need to participate in an arbitration or even accept its results, but at the same time, I can receive the benefits of the convention without accepting the burdens, right? So the coastal states say your sovereign discretion was exercised when you acceded to the convention. How do they reconcile that?
With great discomfort, ultimately. I think that, the clearest example of this coming to a head is the South China Sea arbitration, the Annex 7 arbitration that the Philippines brought under the law of the sea treaty against China in 2013, and that had an award, or a final binding award in 2016. That is a big contradiction for China, because ultimately, yes, their international lawyers and their diplomats and the people who understood the nature of that treaty obligation, of course, knew that signing the law of the sea treaty entailed a compulsory dispute resolution mechanism. What I will say is that they objected to that throughout the negotiation, and it's on the record, the Chinese delegation, people no less eminent than Wang Jieya, the Jerry Cohen of Chinese law, as it were, in China, had his only statement on the record at the UN Law of the Sea conference saying China doesn't like the idea that any sovereign, basically it's, boundaries or entitlements, as the arbitration with the Philippines involved, at some step of the way down, as anybody familiar with law of the sea understand, there is some question of territorial sovereignty somewhere. And basically, Wang Jieya saw that and said, we're not going to like this type of a third-party dispute resolution mechanism. And when China did ultimately ratify the convention in 1996, they had an extensive discussion that just covered in public, including, the National People's Congress deliberations over it, where they were explicit in saying, this is not a good system for us. They said there are treifa, like shortcomings, defects, a variety of other things. And that was on the record, but on balance, they felt it was in their interest to ratify the treaty and to write, when they ratified it, in a statement, even though you can't make reservations from this treaty according to the treaty itself, they said a vague thing. They said, we accept bilateral, they listed off the different ways that they're willing to resolve disputes, and they don't include the compulsory dispute resolution mechanism. So by inference, they're saying you can do bilateral dialogue and consultation. 对话协商, that's what you can do. There's no other alternative when it comes to our sovereign rights and interests.
Well, China attempted to find other pathways for dispute resolution, including through the declaration of conduct of the parties in the South China Sea with other claimants. And that mechanism was one in which they put, I think the words are a friendly consultation and negotiation, or words to that effect, into the DOC, the Declaration of Conduct. And this Declaration of Conduct, first, perhaps tell us a little bit about what it is, and secondly, why that was not a successful bar to dispute resolution through arbitration.
So the DOC, Declaration of the Code of Conduct, I think of the parties.
Declaration of Conduct.
Declaration of Conduct, that's right. In perhaps advance of a code of conduct, which has been under negotiation since a DOC was agreed in 2002, I believe. And that DOC process started somewhat earlier in the early mid-90s in Indonesia, which has actually been sort of the quiet broker of a lot of this discussion in the region. And effectively, it is, I would argue, a manifestation of China's preference for how to deal with disputes. They told all of the littoral states, all of whom are claimants in some regard. Indonesia is a really interesting case. There's no sovereignty dispute, but there's a maritime boundary dispute, and there's a jurisdictional dispute associated with it. What China was able to do is engage them all in a discussion about dispute management, not resolution, because resolution involves disposition of sovereign territory, which, again, maybe the door is open. We've seen China do it with Vietnam in an earlier era. But ultimately, the only thing that's open for discussion in the context of international law or in the context of multilateral negotiation is basically joint development of some kind. I would argue that's what the DOC has as its, potential concrete implications, is that they could have a modus vivendi, no resolution of disputes, but some mechanism whereby you can use this space. And so what the DOC ended up being was basically, non-binding, non-specific set of agreements among parties to the South China Sea dispute, which is to say all the littoral states, that they just wouldn't do anything to prejudice future claims, and they would avoid. I actually am not as familiar with all the individual articles as I used to be when I went through it, other than to say they're not particularly specific about anything, and it's done in theory in preparation of a binding code of conduct, which would specify certain things about who gets to enforce their maritime law where in the South China Sea. Might be one way of thinking about it. And I think what China has put on offer is that basically they're going to have a veto over just about anything that happens in the South China Sea. They might be able to accept certainly some level of sovereign rights for other coastal states. In fact, and this is one of the reasons that I think that their practice is so non-uniform and inconsistent, there's been Indonesian and Malaysian and Vietnamese and Philippine exploitation of resources that China nominally claims, maybe with its 9-dash line, certainly with its extreme projections of an EEZ from all of these submerged features, things like that. We know China doesn't accept those claims, but I think the DOC and this, I would describe the whole thing as one process, and it's China's multilateral process for engaging the other claimant states, and I would say dragging out, or rather suspending or sustaining the fact of there being sovereignty disputes indefinitely, and negotiating politically on what that means for use of the South China Sea.
It really has been a stabilizing system to some degree in the South China Sea over the last now 21 years. I do want to point out that you were talking about earlier about China attempting to reserve itself out of the dispute resolution mechanisms of UNCLOS, but that the convention itself does not allow parties to reserve themselves out of. And I just want to say, so did the United States, right? So the United States objected to those dispute resolution provisions as well, and therefore has not been able. The convention hasn't gotten through the Senate, right? Because just for that exact reason, and you see a certain a really mismatch, right, in sort of how the two states have approached dealing with that particular problem. But I want to actually, I'm glad we have the map still up here. I do think in a minute we should take it back down, but I really wrestle with this question, which is the dilemma that both international law is presented with by the case of China, and frankly that China is presented with in the context of international law, which is does China see itself as exceptional and its claims as exceptional to international law? That is to say, international law applies globally, except for China, in China's case. Or does China see itself as somehow consistent with international law? And the reason I say this is one thing that in my engagement with the Chinese, I don't see a sort of the follow through, the logical conclusion of in the Chinese approaches to international law as to the effects of what they're doing, right? Which is to say, China is a powerful leading state in the international system, whether it's in East Asia or globally. China is a powerful leading state, and their powerful leading states set the example for other states. And whether China intends its example to be followed by others, as China sets its agenda, it now has made room for other states to follow that agenda, right? That inevitably shifts international law in ways that China may not intend, in fact, may not even like, right? So I wonder whether you have wrestled with this dilemma and wrestled with your Chinese counterparts about this dilemma and what you think about it.
Yeah, that's an exceptional question, and it's very difficult to answer in generalizable way. But that's something that I've wrestled with a lot, and we've discussed with in various different contexts. I think that China wants to have its cake and eat it too on that first kind of dilemma you present. Do they think they're exceptional, or do they think they're consistent with international law? I think they want to reconcile those views, and I think the vehicle for that is specifically this very expansive view of sovereignty and sovereign discretion. When you hear their senior diplomats and international legal scholars and officials talk about order, international law and order, they talk a lot about the UN-centric international legal system. And what they mean by—
Of course, this is a UN convention.
That's right. This is a UN convention, and they like the UN as a vehicle for it because of how sovereignty is enshrined there, and specifically how China's sovereignty is more equal than others' sovereignty in the UN. It can't avoid that cynical reality. It's the same for any member of the Security Council. That's a good system. They do have a veto there, no matter what.
Yeah.
Jia Bingbing, notwithstanding, had a very interesting discussion on this with Jose a few months ago. On
At another US ally event.
At another US ally event about whether or not the General Assembly can potentially come over the top. Highly theoretical. I think China's pretty confident that they have a veto in the UN General Assembly and the UN institutionally as a whole. And so what I think that means is that their exceptionalism is codified in the system in some way, and that they see in their cynical historiography of international law, it always being the case that whether it's the British or the Americans or the Japanese, is that some great power is always exploiting international law to its advantage. And in that regard, they shared common intellectual roots with lots of people on all sides of the Pacific and Atlantic, and having a kind of cynical view about international law. And I think that leads to the second part of the question, which is, so what are the consequences of that? What are the effects? And to my mind, the big effect that I see, kind of taking a net assessment from this book, is a regional effect on international law. I think it's fair to say right now that the law of the sea, I think China's law of the sea is a good description of the order in the East Asian littoral.
Back up again.
Not to be too to shill for the book too much, but that's what I think I learned, is that this is a whole discussion going on in international law now. I think Jose Alvarez put it: are there international laws for China, for Europe, for Russia, for Latin America? You can be agnostic about that for now, and just say, from my standpoint as an empirical scholar, looking at what we see in terms of China's practice, and importantly, the practice of other states in East Asia, is that the law of the sea, as I said up front, has less effect on what states can do in that space. China has more, the law of the sea has less, in a very crude sense. Does that affect, say, the application of the law of the sea in the Western Hemisphere, or in the Indian Ocean, or elsewhere? I don't know. You could make a claim that it already has, I suppose, by showing in the form of, for example, the Philippines arbitration, that maybe the dispute resolution mechanism in the law of the sea is not going to solve your problem.
Well, maybe other states will ignore it.
That's right.
I mean,
it could just be totally ignored.
It doesn't take a great power, right, to ignore a neighbor's mandatory dispute resolution.
But by the same token, I think you would agree with me, China hardly ignored that award. In fact, they paid quite a lot of attention to it as a formal matter. They barely ignored it, actually. They tried desperately to ignore it. And
ignored the decision.
That's right.
Actually, yeah, that's right. So fair enough. But now, do we want to eviscerate the dispute resolution mechanisms of?
I think China's view is probably that no, they don't want to blow up the whole law of the sea treaty. And if we read what they said over the course of that arbitration, somehow their argument was, we're the ones upholding the law of the sea by rejecting the jurisdiction of this arbitral tribunal. But that continues to be the policy line. They're not trying to completely undermine the system. It's just they would like it so they have discretion to back it off of anything that has any bearing on Chinese sovereign rights.
The whole purpose for the United Nations Convention, the negotiation of the convention over the course of the 70s and early 80s, was to bring order to ocean claims, right? And a systematic approach to ocean claims. Well, China has both, blown up the claims portion and the dispute resolution portion in its process. I don't know. You might have to rethink whether China's blown up the law of the sea or not.
So let me get back to that. So I think regionally, it's fair to say, like, if I'm Vietnam or I'm the Philippines or any of other states that have claims, I'm not able to exercise my rights under the law of the sea. It's very difficult to say this is an area where you have uniform application of the law of the sea. The bigger level question, and one that I think is ultimately an empirical question that this book is too narrowly scoped to answer, is, okay, so what does that mean for other maritime areas? What China would say, again, kind of channeling what I understand to be the Chinese view on this, is that this is all to the greater good of the law of the sea. And the reason for that is their version of the law of the sea gives primacy to the coastal state. It gives primacy to sovereign discretion. And we see that in their practice globally.
Which largely sets us back 100 years, because that's where it was before we began institutionalizing.
Arguably, that's what the convention was all about.
So listen, I need to see whether we have questions in the room, and then whether there's any questions online. Are there questions here? Are there questions online?
I would, well, first of all, thank you, Isaac, for this presentation. And I always learn a lot from you, and I look forward to reading your book. And I just wanted to ask you if you have been recently observing how China was instrumental in the adoption of the last treaty that was recently adopted at the UN.
The High Seas Treaty?
Yes,
Yeah.
on marine biodiversity in areas beyond national jurisdiction. I think China played a key leading role in the negotiation, especially through the G77, the group of the 77, which has 120 countries in it. And I just wanted to ask you, how do you think the adoption of this treaty that, you know, some people consider as a complementary to UNCLOS, how does China conciliate its views towards with this treaty and UNCLOS?
So that's a terrific question, Nax, and I'm really grateful for it, because that's one of the ways that I'm trying to grow and expand my knowledge from this book into the global commons, as we might call it. And that's what the High Seas Treaty is all about. It's particularly focused on biodiversity and areas beyond national jurisdiction. So the short answer is, just on process alone, China is almost surely going to ratify this treaty. The United States is almost surely not going to. Independent of what the content is, that's part of the policy for China. They want to be in the formal institutional structure. They want to be perceived, at least by the G77, you're right, by a different graphic than the US and its allies are typically reaching out to, as being the one who's upholding the UN-centric international legal system. There's one really interesting norm in this treaty that I'm keen to explore further, and US Ali has already convened a great discussion on this with Liu Nungye from Singapore, who talked in detail about this idea of the common heritage of mankind and its relationship to one of the key, arguably sort of the central ideological position of China in its international affairs, which has to do with the common destiny of mankind. And interestingly enough, I would argue this was the main thing that held up the US in the 80s when the convention was open for ratification, was this idea that there was a supra-sovereign international authority over seabed area, the area.
Initially, that's correct, but it was corrected to American satisfaction in the implementing agreement of 1994. So in the end, what the Senate really seems to get stuck on is the mandatory dispute resolution process.
But I think what we have now is, so even though the implementing agreement largely satisfied the objections we raised then, there are still US objections to this, and part of that has to do with this common heritage of mankind norm, and one that I guess I'm not sure yet, and Liu Nungye said a couple interesting things about it. What's its relationship between China's other kind of core positions about international relations and international law? On its face, they're quite related. There's a sense that there's actually not such a thing as a global commons, which is kind of a liberal idea. It's the idea is you either have property rights over something, or it's everybody's, and you need to solve that collective action problem. From China's standpoint and from the developing world standpoint, there's a common heritage of mankind. There is a deep seabed, and there are areas beyond national jurisdiction that contain wealth. There's data implications. Nobody even knows what the full scope of the value that might be captured in this global commons, but the norm up front, and this I would say includes near and outer space and other aerospace implications. There's a big implication to what China means by common destiny, whether common heritage, which is now codified and enshrined in this treaty, as well as the Law of the Sea Convention in certain important ways, how much that redounds to China's advantage in terms of the ways that it wants to say seabed minerals or not. I sense there's actually quite a tension here. One of the ones that you're pulling at, which is that if everybody pursues their interests the same way China has in its jurisdictional zones, what you have is exactly what created the conditions for the conference to begin with.
That's right.
Completely non-idiosyncratic claims that are in conflict with one another. I don't think China wants to see that.
In conflict with one another, and which tend toward conflict.
Yes.
That's
You
the
have
real,
incentives to take more than you think you can handle because you want to negotiate.
at the lowest level, you have fishing
Yeah.
vessels fighting each other, and then coast guards getting involved. But at a more global level, this has actually started international armed conflict, right? So we're really in a situation now in which international law is going to have to come to terms with the pressure put on it by China. We've got I believe two questions on from the Zoom participants.
Actually, a few more have been added. Let me
Okay,
just
sure.
lay out a couple, and then you can decide what you have in the remaining time, which ones you want to tackle.
Got 9 minutes, I think.
So one question, a couple are very specific, narrow questions, or facially at any rate, narrow. So looking at the map that you just displayed, do you have any idea why historic 9-dash line claims apply only to the South China Sea, but not the East China Sea? So that's one. Another is China stacking their uninhabited islands EEZs and the 9-dash line claim? Or are they separate claims as a backup? I think he means to each other.
I think I understand that question.
Yeah, if you don't buy, he says, in other words, if you don't buy islands, we claim the 9-dash. So, okay, either one or either or type of a proposition.
Let's pause on that,
Okay.
if we can. Those are some good questions. Go ahead.
Those are two quite interesting questions.
Yeah.
So on the first one, that's a specific question that I'm asking in this book in chapter 4. What's the nature of China's historic rights claims or historical rights claims? And one of the things that makes them not rule-like and not rule-forming is how idiosyncratic and how specific they are. China is not saying there's a rule about how you can generate historic rights, whether through long-term fisheries or exploitation or putting up sovereignty markers or all the various, I'd say, spaghetti thrown on the wall about it. They'll just say anything about what justifies it. And this relates to the second question, but I'll stay on the first here. There are shades of historic or traditional claims that we see in the Yellow and East Seas, mostly on fisheries. But China has neither claimed nor tried to put in practice the same type of exclusive or some type of exclusive traditional fisheries rights, for example, in the East and Yellow Seas as they have in the South.
Well, the PRC inherited the 9-dash line. Well,
That's
11, really.
Right. And so that actually gets to the heart of what I understand, what I interpret the PRC's interpretation of the Law of the Sea to be about, which is that they're quite insistent on the historical provenance of these claims and the fact that that is somehow superior to, antedates the Law of the Sea Treaty that they ratified. That's super important in the South China Sea, but not so much elsewhere, because again, it's not that rule-like. It's not quite uniform. It's pretty politically motivated.
Well, one way of looking at it is that they inherited a problem that they had to interpret, whereas they have not complicated their lives in the East and Yellow Seas by extending that sort of conceptual analysis. Not only not complemented, but at least left open pathways of future dispute resolution.
Yes. Yeah, I think that's a better way to think about it. And we did in the first dialogue we did with Chinese MFA officials. I remember this very specifically from their Director General for Treaty and Law, who said that it's the complex legacy of the Republic of China that they view as being defining characteristic of their South China Sea policy and law. Whether they, I mean, I think you could also make the case they didn't have to republish it in 2009 and start packing all of their claims into it. And this gets to the second question, which is that I think there are multiple independent things going on there that have the effect of maybe reinforcing China's claims, but I think the 9- line or the 11- line as it was originally is one line of the Chinese policy, and another is let's apply the law of the sea in a way that maximizes our claims. And so they are complementary in most ways. They're contradictory in other ways, which is to say it's hard to reconcile the EEZ regime with the Chinese 9- line, and yet they have them both in play simultaneously, and neither of them, I think, are what China expects the ultimate map of East Asia to look like, is another way to describe this. Is exactly right in situating this in historical time. And I'm very much of a mind that we're not talking about some generalizable across time and space Chinese view. We're talking about a practical process of China developing what they call maritime rights and interests, as well as the capacity to enforce them.
You know, I'm not so sure that they're so difficult to reconcile, actually. I think a good way to think about them is China inherited the 9- line essentially, and then had to articulate what it would claim on the basis of that line, and as sort of an outside-in approach to making its claims. The line being the outside, and all right, now what are we claiming on the inside? Of course, sovereignty over all of the islands and features within the 9- line, but then some historic rights to the water space. But at the same time, China has made clear in its communications to the UN and in its response to the arbitration that it also claims baselines around the island groups. We know that.
Put up that map, I'll show you this.
Yeah, baselines around the island groups on an inside out basis, right? So it's both outside in, inside out, and the inside out portion is claiming baselines around the island groups and then defining zones from there, right? And that the two work together, I think, in the Chinese perspective.
Yes.
And that the Chinese have been fairly clear that the 9- line is not necessarily a permanent line. It is the starting point for the negotiation.
Provisional
process.
is one of the words that has
That's right.
been used by people like Gao Zhiguo.
So if you think about it as a provisional line around which bilateral negotiations can be undertaken on the basis of these two essential claims, right? That
sovereignty over those island groups.
That's right, but also the inside-out approach, right, which is the EEZ zones, and then the outside-in approach, which is the historic rights claims. You can see how that might be a starting point.
It's an independent,
bilateral,
complementary way of them pursuing this objective. I like the inside
out, outside in, I think is the way to think about it.
And again, for folks not as clued in on law of the sea, the inside out is basically what the treaty says. It says you have sovereign territory and you can project out zones. They're defined entitlements, whereas the 9- line is obviously an external line, and it's saying something about maritime jurisdiction internal to it. It's worth noting, back to this kind of inheritance from the Republic of China, it's quite clear now that that was not what the Republic of China intended at the time, nor is it what the current government of Taiwan, the Republic of China, interprets that line to mean. Ma Yingzhou, who is a student of Jerry Cohen's and wrote a JSD dissertation about the law of the sea, East China Sea, oil and gas stuff in particular, articulated this very clearly opening an archive several years ago. It was always a claim. The name of the map is the position map of the islands in the South China Sea. They were describing the sovereignty claims of the Republic of China and not knowing where all the features were effectively. That's the basic story. Right. It was a big space with a lot of submerged features that some fishermen sailed by and it was above tide, and another fisherman sailed by and it was below tide, and they just don't know. And so that's what the claim was. The Taiwanese Legislative Yuan contemplated in the 90s as the treaty was coming up for signature and was about to go into effect, whether they wanted to make a historic rights claim on the basis largely of the 11- line and determined not to, precisely because it was so obviously in tension with the exclusive economic zone regime and the continental shelf and
Well,
everything else that.
And the international law of historic rights. Let's be
Right,
honest.
yeah, leave aside whether or not the claim would win on the merits, just
Yeah.
whether or not they want to pursue that line. And it makes it quite clear to me, at least, and other people, Bill Hayton, we were just talking about his book on some of the sort of the historiography or the problematic historiography here, is that the mainland, for a variety of reasons that we won't have time to discuss in the next 12 seconds, decided to make it a much more of a creeping jurisdictional
Yeah.
claim than it was originally intended to.
Okay, so we're just about out of time, but I want to leave you with a question, which is, you mentioned Bill Hayton's book, and I think what you're referring to is The Invention of China, terrific book. What books would you recommend people to read on the basis of, if they're interested in this topic more broadly?
Sure. Well, I would say we should all go back and read Jerry's books with Hung Da Cho, which
Yeah,
we were just
yeah,
talking about,
yeah.
which in 1973 and 1974, they did the most comprehensive survey of China's practice of international law possible. It's proliferated quite since then. And I think starting from there will give you a lot of really good ideas about questions that you might ask.
And what about for the more general reader?
And for the more general reader, I do think Bill Hayton's book is quite good on this.
Yeah.
I do think Peter Dutton's forthcoming book, which we'll all expect to see, is really quite excellent. And yeah, not surprisingly, it's the folks from US Ollie and who've been convened here. Adele Karai wrote a terrific book on the genealogy of Chinese sovereignty, which I think is a really nice complement to this. And I would commend to the international law students and international relations students too.
Well, US Asia Law Institute is at the epicenter of all these work. So that's good way to end the session. Thanks very much, everybody. Please